Ethical Dilemma in School Counseling. My name is Matthew Ross. The ethical dilemma that I was dealing with, according to Stone C 2022, was Scenario 3, where Robin is a sole counselor in an elementary school in a rural county. She was told by a parent who wanted to divorce that their 9-year-old daughter is afraid to be alone with the father. The parent asked Robin not to let the father pick her up and not to release the student's record stem. Now, identifying the problem. The problem mainly focuses on the professional roles that I serve in a rural area as a school counselor. Now, the main problem is the safety and well being of the student who is afraid to be alone with the father. The secondary problem is the lack of resources and support in a rural area for students with family issues. The ethical problem is I need to consider confidentiality and informed consent when getting information from the parent. The legal problem are the issues that may be raised in terms of custody and right to access student records. The clinical problem is I may have to counsel the student for the emotional pain and trauma that has come from their family turmoil. The professional problem is I am the only counselor in the county, which makes me feel alone when it comes to decision making. The technology problem is security and confidentiality of student records can be breached if the father is denied access. Now, the ASCA standards and the ACA codes. Now, the ASCA ethical standards A.4.A is to protect the confidentiality of students' records. A.1.E is to communicate to students and parents the importance of confidentiality. The ACA Code of Ethics B2.A is respect confidentiality. A.4.B is clients' rights to confidentiality should be discussed with clients and documented. B.4.A is understand and describe the limits of confidentiality. Now, the Maryland Family Law 9-101 highlights that child custody and best interest of the child, which may have applications in divorce proceedings and child welfare. Maryland Education Article 7-111, this section lays out clear and heavy emphasis on student confidentiality and parent rights to students' education record. Now, federal laws, Health Insurance Portability and Accountability Act, also known as HIPAA. Although it's intended for use with health information, it highlights the need for confidentiality with vulnerable patients that could also be applied in this case for information regarding the minor. Family Educational Rights and Privacy Act, also known as FERPA. It protects the privacy of student education records as well as provides parents with specific rights with regard to their child's records. It's applicable to this case because it would be related to the father's access of his daughter's education records. Child Abuse Prevention and Treatment Act requires reporting of and action to prevent treatment of or care that might lead to child abuse and neglect. This is especially relevant to this case because it's the basis of the parent's concern. Now, moral principles, autonomy. I will keep the parent's request for her daughter's safety in mind and will not breach her right to privacy and confidentiality. Non-maleficence. I will not cause harm to the student if she has indicated a fear of her father. Then I will ensure that she is not placed in a situation that will further intimidate her or result in emotional and or physical harm. Beneficence. I will work to prevent the student from becoming distraught and will help to ensure that her father's access to the daughter is blocked. Priority principle. Non-maleficence has priority as the student is scared to be in the father's presence. Expert opinions and ethical dilemmas. Harmon and Scheffner-Rogers, 2019, reiterate the importance of a school counselor's ability to participate and preclude possible risk to a child's well-being. They state that if a parent brings up their child's concern and their child's safety at home, and in the case of parental separation, a counselor is expected to pay attention to the provided information and its possible implications. Williams and Vaughn, 2020, also focuses on the counselor's responsibility to adhere to ethical standards and norms even when there is a potential for dual relationships and connections, which is common in small regional communities. The article specifically notes the legal age of consent and one's ability to provide for their child's welfare independently. The article also notes that for counselors such as Robin or myself in this case, who may be aware of the child's family or even know them personally, it is even more important to keep the student's safety as the primary priority while maintaining their confidentiality and privacy. Bacon Rap 2021. Note that it would be the best to seek consultations and supervise from other counselors and colleagues as they practice the counseling profession. This can help preclude any ethical or legal issues and serve to the best interest of the child. My consultation plan. First, I would consult the supervisory counselor, which is a supervisor or a more senior colleague who can provide guidance and support regarding the ethical implications of the situations. They can offer insights on possible legal and ethical actions that I may consider. The peer counselor, who is a colleague who works in a similar setting or community and is familiar with the specific circumstances and cultural norms. This counselor can share their experiences and provide advice on how to handle the situation from their perspective. Organization for consultation. The American School Counselor Association, the ASCA. The American School Counselor Association is a national organization dedicated to supporting school counselors. It provides guidelines and resources on ethical practices and issues relevant to the school counseling profession. The ASCA can offer information and support specifically tailored to school counselors facing dilemmas similar to the one in this case. The National Board for Certified Counselors, NBCC. The NBCC is a certification organization for professional counselors that sets ethical standards for the profession and offers resources for counselors to meet these standards. The NBCC can provide me with guidance on my professional ethical obligations and the steps I may need to take to address the ethical dilemma. Potential courses of action. Now, the first thing is review confidentiality policies. I can immediately review and, if necessary, update the school's confidentiality policies to ensure that the student's information is adequately protected. This could include consulting with the school administration to reinforce the importance of keeping the records confidential, particularly in sensitive cases such as parental divorce. As per the Families Educational Rights and Privacy Act, FERPA, guardians are entitled to have control over their child's educational records unless there is a court order indicating otherwise, and that comes from the U.S. Department of Education 2020. I could provide resources and support. I could compile a list of resources and support services that the student and other families in similar situations can access. This could include providing contact information for local counseling services, support groups for children of divorced parents, and other community resources that may be of help. A study published by the American Psychological Association emphasizes the significance of accessible support resources in aiding children to cope with familial changes. That comes from the American Psychological Association 2019. I could arrange a meeting with the parent. I could schedule a private meeting with the concerned parent to discuss the situation in detail. During the meeting, I could gather more information about the student's fears and concern, as well as the parent's desires regarding legal measures. This conversation could also provide an opportunity for me to offer more targeted support to the student. By building a rapport with the parent, it may be possible to work together more collaboratively to ensure the child's safety and well-being. 4, alerting school administration and law enforcement. In cases where the situation becomes more serious or if there are signs of potential harm to the student, I may need to take proactive measures to inform the school administration and, if necessary, law enforcement to ensure the child's safety. The duty of reporting suspicions or concerns about a child's safety falls under the legal and ethical responsibilities of school counselors, and that's according to the National School Counseling Association 2021. All right, but now the potential consequences of reviewing and updating confidentiality policies. Let's start with that one. For me, the consequence, I might be able to have clear understanding of the policies and legal issues surrounding student privacy. On the other hand, if I do not adhere to these policies, I might break confidentiality and suffer legal consequences. For the client, the student and the parent in this situation, the student's confidentiality would be respected, which is especially important at a time like this. The parent might also be satisfied knowing the child's information is being treated properly. For others, other students and parents could benefit from the implementation of stricter confidentiality policies, building a more trusting school environment. It may also cause confusion if staff members are not properly trained on new policies. Potential consequences of providing support resources. For myself, sharing resources can show that I care about my students. However, if others know that I shared information on a divorce, it may show that I do not have good professional boundaries or confidentiality skills. For the client, the child and the parent may have support, not feel so alone, and cope in a healthier way. However, if the resources are unavailable or not relevant, they may feel discouraged after the effort. For others, other families could also use the resources, which might make the community better able to cope with the crisis. The potential consequences of scheduling a meeting with the parent. For myself, meeting with the parent can help build rapport and trust, allowing for better collaboration. However, if sensitive information is disclosed during this conversation, there could be risks associated with confidentiality and my responsibilities as a counselor. For the client, the parent may feel heard and supported while the child could receive tailored assistance. However, if the meeting leads to uncomfortable discussion, it may strain the counselor-parent relationship. For others, other students may benefit from my proactive approach if it leads to better informed decisions about safeguarding their welfare. Potential consequences for alerting school administration and law enforcement. For myself, it will make me feel that I have taken an important step in keeping the child safe and I will have met my legal and ethical obligations. It could potentially divide the school community if parents feel their right to privacy was not respected. For the client, the child will immediately benefit from a sense of safety and security. The child may, however, experience an increase in anxiety or a sense of betrayal upon learning of the report. For others, the school may take action to provide extra protection and safety for their students. Parents may, however, feel worried about reporting similar sensitive concerns. Eliminating actions based on consequences. Review and update confidentiality policies. This action will not be eliminated. This will allow for all students' rights to be protected in the future. The consequence of this has been seen, but the results are greater than the risk. Providing support resources. This action will not be eliminated. There is potential to be misunderstood, but there is a greater impact for the student and other families in the same circumstances. Scheduling a meeting with the parent. This action will not be eliminated. This is allowing for open communication. The consequences of this will be possible confidentiality breaches, but there is greater need to gain trust for better counseling. And the last one, alerting school administration and law enforcement. This action should not be taken unless further information is shown that the child is in actual danger. This could be an action to be eliminated. There is no evidence of the real case in which the child has a possible fear of deportation. If there is no clear evidence that there is a risk of this, but it could potentially hurt relationships with law enforcement and other families, this could be an action to be taken if further information is shown on the child's safety. So I don't see a safety breach here with the child. My chosen action. Now, the action that I chose was arrange a meeting with the parent. Now, for the test of justice, let me jump right into it. Scheduling a meeting with the parent is fair as both parent and counselor will be engaged. It also allows the parent an opportunity to have an equal voice in the conversation and be heard. I would like to support the student and parent, but also be conscious of ethical principles that govern my work. The overall positive impact on the child could also allow for the fair access to resources needed during this challenging time. Test of publicity. This course of action could pass the test of publicity. The action that I would take could be reported to the press and it would have a positive public reaction. The action could potentially maintain confidentiality and increase support for the student. The counselor could be seen as being more proactive in handling a sensitive situation, and scheduling a meeting could show the parents that the counselor is trying to help me, even with some concerns about confidentiality. Transparency is in my best interest. I am trying to be transparent by informing the parent of her role and that I support the student. Universality. And my overall conclusion. This solution is the best one as it will allow the counselor to maintain the child's best interests and hear the parent's concern in action. I would recommend this course of action to a coworker. The course of action could pass the test of universality. While there could be some ethical dilemmas with the first two principles, overall, this course of action would allow open communication with the parent and collaboration. All right. Now, the steps to implement my decision. It's my last slide. Step 1. I need to review the case. Before contacting the parent, I should review notes or records on the student's case to prepare for the meeting. This includes researching the child's background, prior interactions with the student, and any existing concerns about the student's safety or well-being. Step 2, consult with administration. I should schedule a meeting with the school administration to discuss my intended approach to the conversation with the parent. I should seek advice on how to maintain the student's confidentiality and any school policies that may impact my actions. This will ensure full compliance with school policies and a clear communication plan according to the American School Counselor Association 2021. Step 3, contact the parent. I should call or email the parent to request a meeting during which I can express concern for the child and offer support while ensuring that this communication is respectful of the parent's situation. Step 4, prepare for the meeting. I should prepare a list of key discussion points and have resources ready to share with the parent during the meeting, such as information on community support services or counseling options for children. Step 5, conduct the meeting. During the meeting, I should foster a safe and welcoming environment for open dialogue and listening. After hearing the parent's perspective, I may share my observations about the child's behavior and emotional state. I should be careful to respect the parent's disclosures and navigate the conversation without divulging information that will breach confidentiality. Step 6, document the meeting. I should document the meeting, including the key points discussed, concerns raised, and next steps agreed upon. This record should be stored according to the confidentiality guidelines. Step 7, follow-up. I should schedule a follow-up meeting or check-in with the parent to discuss any changes or developments in the child's situation. This follow-through will help to maintain the trust established during the meeting. Assessing the course of action's effectiveness to assess whether the course of action was effective. I can consider several factors. Feedback from the parent. After the meeting and follow-ups, I can collect feedback from the parent about the experience and whether they have noticed changes in their child's behavior. This could be done through a short feedback form or informal conversations, monitoring the child's well-being. I can evaluate the student's emotional state and behavior at school following the meeting to determine if the conversation with the parent has had a positive effect on her well-being. This can be done through regular check-ins or by working with teachers. Changes in engagement with resources. I can assess whether the parent or student has followed up with any of the resources provided during the meeting, as this can indicate the effectiveness of the course of action. If the parent or student is transparent about about using support services or resources, it may reflect the collaborative effort made during the meeting. My conclusion. In conclusion, scheduling a meeting with the parent serves as a constructive course of action that promotes open communication and support for the child amid family challenges. By systematically implementing the steps outlined, consulting with administration, and ensuring effective monitoring of the situation, I can navigate the complexities inherent in this role while adhering to ethical standards. My references are the last two. Thank you so much for your time this evening.